Where'd she go? This is so strange. We're not on the stage. Can you guys see me and hear me? It's the weirdest thing. Okay. Well, hey, y'all. Okay. I don't know what's happening, but happy Saturday. We're having some technical problems, but I can't even see who's here. And I don't know if it's appropriate for me to just start, but you can type in your questions. We can do pre-questions. What do you really want us to talk about? Aha, that's funny. Am I going to sing my presentation? Hi, Jaia. Can you see me and hear me? Jaia.
Hear me?
Yes, I think we're on now. They said they see and hear me. Do you all see and hear Jaia?
Okay, but they.
Yes, they said yes. But you're cutting out on my end. I don't know if they can, if you're cutting out. Is she cutting out? She's lagging. Yeah. It's that California lag. That's okay, girl. Hopefully we'll get it. Look, we'll type our responses. Either way, they're going to get some jewels today. So hi, Jaia.
Hi. So I don't know if we should just jump in. Is there like a really big lag when I speak?
Yeah.
Okay.
That's okay. They said it's better now. So just go ahead. They'll let us know. I'm reading the chat.
Okay. Well, we'll just jump right in. Sorry, guys, for the delay, and sorry for all the technical difficulties. Hopefully the lag will end soon and you guys will hear me in real time. But we can just jump right into the conversation. By way of introduction, my name is Jaia Thomas. I am a Los Angeles entertainment lawyer. I'm also a professor at UCLA, where I teach a course on copyright law and the entertainment industry. I'll turn it over to Kimra to give a short introduction about herself as well, and then I'll give an overview.
Thank you, Jaia. So you guys, I met Jaia. I'm a Jaia fan because I just love what Jaia has done with diverse representation. She and I shared a panel together at FAMU Law. But yes, my name is Kimra Major-Morris. I am an intellectual property attorney of almost 12 years. And I've just been really fortunate to have chosen this particular practice area. Did not know what I wanted to be when I grew up. I started off as a hip hop artist. I was Bo Peep with Rhymes for the Lost Sheep, and I Dare Somebody Laugh. And then I became a mom, and I put my microphone down so I could feed my child. And I pivoted to what I majored in, which was television production. And so I did have a job working with Bobby Brown in his studio in Atlanta in '94 for a few years. That was fine. But I did notice that the music business was not stable. And so I moved from that job and the music industry work that I was doing the promotions. I just wanted to stay close as I moved away from being an artist. And I started doing video production work. I was a video editor for HBO for about 5 years and did a bunch of red carpet stuff for BET, Spring Bling photography, just having a lot of fun. But I did think that I should go back to school just so I could have some independence and then still work with creative people. So I went back to school after being out for about 13 years. And I have 2 daughters, and I just wanted to set a good example for them by being able to write my own checks and still work in the entertainment business. So I thought I wanted to do entertainment law, and I stumbled upon intellectual property law. I had not even heard of it as a practice area. And the reason I chose IP was because I don't live on the West Coast. Disney is here in Orlando where I am, but the Disney attorneys are in California where Jaia is. And so I thought this way, if I do IP, then I can cater to not only the artists, the creative people, whoever's referred to me, but also the tech people, the business owners who still need brand protection and, whatever talent. So it has worked out really well for me just because of everything that has gone on with technology. And I'm just really fortunate to have been in this space as long as I am. I taught at Full Sail University. And I continued to do video production work until I graduated from law school, until I couldn't juggle both anymore. So now I serve creative talent, including TV people, music people, gaming people. I also represent families of victims that we see from senseless violence, such as the George Floyd family, Trayvon Martin's family. And so that's a different kind of brand protection and licensing that I've been able to experience. But for the most part, I'm representing a lot of small business owners and, you know, people in sports and entertainment. And so I'm here to answer questions and educate you about the IP basics because it really does intersect with everything. So.
Definitely. So excited to have you today. And we're going to keep today's conversation just like super casual. We're going to provide a general overview of the different types of intellectual property, and then we're going to open it up to Q&A from you guys. But we're going to kind of just jump right into what is intellectual property, because a lot of artists are always talking about intellectual property and they need to protect their IP, but often the differences when it comes to the different types of intellectual property. So there are three main types of intellectual property: copyrights, patents, and trademarks. Today, we're going to be spending the bulk of our time talking about copyrights and trademarks. A lot of clients always come to me and they're like, oh, I want to patent my, you know, my music video, or I want to trademark my book. And it's like, I know what you're trying to say, but that. So yeah. The first thing before we kind of even get into trademark and copyright, what are the differences? What is a patent? What is a trademark? And what is a copyright?
Okay, so a patent is an invention. And like Jaia said, we're going to spend more time talking about the copyrights and the trademarks today because they tend to be the more commonly used pieces of intellectual property in the entertainment space. My computer, sorry, the fan was making a lot of noise because it was sitting on the cord. Okay, so copyrights are for creative works. Examples of copyrightable works are musical works, literary works, gaming, the storyline behind the game might be one thing if you're in gaming. If you are a business owner, then you have marketing materials. So that's designed a certain way. You have graphics, the wording is expressed uniquely. And so every business owner has some intellectual property. And a lot of times people don't recognize what it is, but this is why I really enjoy working in the space, because getting to know what you own is just as important as protecting it, because you have to have some strategy if you really want to leverage it. So copyright is for the creative works. Even software code. The software code can be copyrighted because it's literary once you type it out. It becomes something that's eligible for patent protection when it's a brand new kind of software. So not the subject matter, which would be the difference between Lyft and Uber Eats, right? So one is delivering people, the other is delivering groceries. So you wouldn't get a patent for that same kind of software, but if it's something totally new, where you have something that's going to take us to the moon, you know, by tomorrow and back, you know, for the people who aren't on the spaceship, and that might, you know, that would be a patent. So copyrights, creative works, trademarks, you think business owners, brand protection. Trademarks can be business names, or they are business names. They're the things that identify your business, which can be the name, the logo, the slogan. If you have a tagline, it's kind of similar. Even sounds, the NBC chime, smells. I've been in Verizon stores where they have a smell, they submit that somehow to the trademark office. But things that identify your brand are the trademarks. So patents are inventions, copyrights, creative works, trademarks for brand protection. And the fourth one is the trade secret. And trade secrets drive your revenue. Think companies that keep their trade secrets to continue to create value or add value to their bottom lines. Coca-Cola, you know, we know it's a carbonated drink, but we don't know what's in it. KFC, we know fried chicken, but what's the process? So those things are kept protected by contract. You never register a trade secret because then the secret would be discoverable. So.
Great breakdown. Thank you. So I am going to spend a little bit of time talking about copyrights, and then I'm going to have Kimra talk about trademarks, and then questions from you guys. But just to provide a general overview about copyright protection, what it is, how do you get it, what is required, I think is really important for content creators to understand. So as Kimra mentioned, copyrights protect creative works. So if you have a book, a comic book, a record, any type of creative work that you create does usually qualify for copyright protection. One of the common misconceptions people have about copyright protection is register it for it to be protected. Actually, you have a copyright the minute that you actually create something. So the minute you write your book, the minute you draw your comic strip, at that moment under the law, you actually have a copyright right then and there. Register Copyright Office just adds an extra layer of legal protection. So that's one thing to keep in mind. And I'm sure you're probably wondering, well, what is that extra layer of legal protection? Why should I register it with the Copyright Office if I already have a copyright the minute I create it? And advantages of registering your work with the Copyright Office is that you can sue for copyright infringement. So if you register with the Copyright Office and then I come along next week and just copy your book verbatim, Copyright Office, you would then have the right to sue me for copyright infringement. So that's one of the key advantages of registering your work with the Copyright Office. But the minute you actually create something is the minute you do have a copyright. So now if we jump into copyright registration, look like, what is required? So going back to the book example, let's say you guys write a book, all of you write a book right after this panel is over, and you want to register with the Copyright Office. Required to register a work with the Copyright Office. There are three main things that are required when you are registering your work with the Copyright Office. Number one is the application. And honestly, the application itself is very easy. It's about 2 pages long. It's very straightforward, very simple to complete, and you can complete it online. So that's number one, application. Number two is the application fee. There are various fees to register a copyright, but at the base level, it's $45 to register a copyright with the Copyright Office. And the third thing is, so when you register your work with the Copyright Office, you have a copy of the work. So the book that you wrote, you would have to provide them with a copy of the book. Does it actually have to be a physical form of the book? Do you have to put it in mail and ship it US Post Office? No, you can send them an electronic version as well. But those are the three main requirements: the application fee, which starts at $45, and a copy of the work itself. So once you submit all of those things to the Copyright Office, how long does the process usually take? Once you submit everything for you to receive your copyright registration certificate. So it can actually, it can take anywhere between 6 months to 9 months, depending on the backlog of the Copyright Office. Sometimes they have a backlog of, hundreds of applications, thousands of applications, and it can take a while, but on how long it takes. A lot of clients always ask, well, what happens if I make a change? What happens if I register my book with the Copyright Office, but then, the following week I edit that book? Do I have to register copyright? What does that look like? And the answer to that question is, it depends. If you're only making very small edits to your original work, maybe you're just fixing some grammatical errors or adding a new word here or there, and that situation to re-register the work with the Copyright Office. It's only if you're making substantive changes to your work, maybe you're adding, completely new chapters. In those type of situations, you would then have to register that brand new work with the Copyright Office. But if you're just making these minor edits, changes, things like that, you don't have to re-register the work with the Copyright Office. A lot of my clients always ask me, and I don't know how a lot of you guys, but I represent a lot of people also in the television and film space. And especially in the television space, a lot of people always have ideas for television shows, ideas for web series. Does the Copyright Office protect ideas? And the answer to that is no, they do not. So if all you have is just an idea, for a show or for a project, ideas in and of themselves cannot be protected with the Copyright Office. Only if you actually have or a book, that you plan to build those ideas off of, can those types of works be registered with the Copyright Office. But ideas in and of themselves cannot be registered with the Copyright Office. You can register ideas with the Writers Guild America, and no, you don't have to be a member of the Writers Guild to register a work with them, but registering works with the Writers Guild definitely does not provide nearly as much protection as registering your work with the Copyright Office. And one other thing to make note of is that some states do have specific laws in place for idea theft. California is one of those states. So even though you cannot register your idea with the Copyright Office in the state of California, and I don't know where a lot of you guys are tuned in, vary from state to state. Some states do have specific laws protecting ideas and idea theft. So in California, you can actually sue somebody for idea theft, but that's on a state-by-state basis. So those are kind of some of the things to think about with regard to copyright registration, copyright protection. One other small note I want to make is also when registering a copyright, you can have more than one copyright owner. So, the entertainment industry is a process. Oftentimes there are multiple people working together on, and you can list multiple owners, multiple authors on your copyright application. So that's something, to keep in mind as well. But that is kind of a general overview about copyright, copyright protection. The fee is, like I said, only $45 to start at the base level. So I do always recommend to my clients, to register your copyrights as soon as possible, make sure everything is protected. And like I said, it's a very straightforward process. Registering a copyright is much easier than registering a trademark. So something I definitely recommend to all of you guys. So transitioning into trademarks, I will now turn it over to Kimra. I have a few questions for her about the trademark process, and then we can take, your questions. Yeah. So Kimra, tell me what should a content creator, should a creative start thinking about registering a trademark?
Thank you. I liked your explanation for the copyright registration process. I also want to add that when people have these copyright registrations and they enter into contracts, it's a good idea to have non-disclosure agreements, particularly for artists and filmmakers, for example, when they share their works, their pending up and coming things. You add another layer of protection when you have a confidentiality agreement. That way, if your idea is stolen, then you would have two causes of action. One would be for the breach of contract and the other would be for the copyright infringement. So that's just another thing that people can do. For the trademark process, people think that they have to have their work in the marketplace to start the process for trademark protection, and that's not true. You can actually register or reserve a name with the trademark office to protect yourself. And the good thing, the advantage in that is, number one, it's a long process. It takes 6 to 12 months and sometimes longer, depending on where if there are any snags in the application process. But the sooner you start it, the better, because what you're doing is reserving your spot with the USPTO, which stands for United States Patent and Trademark Office. If you'd like to read about this stuff after our discussion today, go to uspto.gov. Also, for the copyright information, go to copyright.gov. The USPTO just yesterday did a workshop on the copyright registration process. So like Jaia said, that's really pretty straightforward. But the trademark process, so many things can go wrong. But the sooner the better, because you're reserving the right, and the trademark office will not let anyone else. So people are afraid, well, if I put my idea out there with the trademark office, then somebody's going to come along and say that they were doing it first. Well, there is a presumption under trademark law that you are the first to do it if you applied first. Now, there are some other things that can happen later on in the process because sometimes people do go around. But the point being, do it as soon as possible. Don't wait until you actually have products and services available to initiate the process.
And what does that process from a very like high level, what does that process look like in terms of registering a trademark? What are some things people need to be aware of, think about before even going down that road of trying to register?
Well, if you're not in the United States, then you do need a U.S. attorney to help you file that application. That is the law. You can't have foreign agents helping you with the U.S. registration process. You also want to, people think that their brand name or the business name has to match the trademark. It does not. I could go and apply for a trademark under my personal name, and then later I could assign it to the business or the holding company that I want to own the trademark. So a lot of times people wait because they say, oh, I didn't register my business yet. You don't have to wait for that. You can also, what does it look like? You go to uspto.gov. A preliminary search is something that is highly recommended, and everybody can do a basic search. But the basic search, unfortunately, is something that people have relied on and wasted valuable time and money. So the basic search looks like you going to uspto.gov. There's a tab that says Find It Fast, and you can click on the tab that says Trademark after that. Once you click on the trademark tab, you're going to select something called Search the Trademark Electronic Search System. It's called TEST for short. So once you get into the test menu, the very first option says Basic Search, and that's the one that you would click on to do a preliminary search. So uspto.gov, click on Find It Fast, which would be toward the right of the screen, click on Trademarks, then click on Search Test, which is the Trademark Electronic Search System. Click on Basic Search, and then type in the name that you're thinking about protecting. Now, I will caution you that a lot of times people type in exactly what it is they want to protect, and that's one of the problems, just one, because the trademark law pays attention to how what's called the commercial impression. So that means if I want to register a trademark for Jaia, and I go and type in Jaia, and then I don't see anything that comes up, then the average person that I talk to says, I searched it and it was available. That's my favorite. So I don't laugh out loud, but I do laugh on these calls because it could be spelled Jaya. Jaia, give us some name variations, how your name could be spelled. Yeah.
Girl, I've heard it all. Jaia, J-A.
Okay. All of it. So if you type in something other than Jaia, the one and only Jaia on this panel, then, and you think it's available, then Jaia is coming for you, because Jaia is going to say, no, you are not the real Jaia. I was using this. And even though you added all these vowels, you added like 5 E's to yours, it's still Jaia. And it still sounds like Jaia. So that's one of the most common mistakes people make. But okay, you can do the preliminary search to kind of weed out the obvious ones, because if you wanted an apparel line called Nike, then you would find that there are pages of Nike trademarks. And so you can kind of rule out the obvious ones before you go and get an attorney to do what's called a comprehensive trademark search. But it is, it's not. And go ahead, Jaia. There's a delay.
Oh, no, go ahead.
I was going to say that, so once you do your preliminary search, then you should sign up with a trademark attorney or a trademark professional and get a comprehensive search done. And then you'll get what's called an opinion letter that will tell you if it's worth investing in this thing. Because a very common misconception is that the trademark has to be exactly the same in order to be something that you can't use. And going back to the Nike example, if I start an apparel line and I call it Mickey's, and then I use a swoosh sign, I'm going to get flagged, right? Because it's confusing. These are consumer protection laws, the trademark laws are, and they're out here to help us to protect not only the brand owner, but to protect the consumers who would get confused about whether they're buying a computer by Apple or if they see one called Peaches, right? Right, and they think it's a sister company. So these trademark laws are out here to help us to be clear about the businesses or the brands that we're purchasing from. So,
are there any other common misconceptions that a lot of people have with regards to the trademark process that you see, whether it's your clients or just people in general? Are there other common misconceptions that you run into?
Yeah, another one is that people think when they have a trademark pending or even when they have a trademark registration, they think that they have a trademark for everything. So the way trademarks are protected is that you have to tell the trademark office what goods and services you sell, what products and services you sell. And so this is a good example. So my name is Kimra, and I discovered that there was another Kimra. Gasp, right? So there is another Kimra out here, and she is a marketing professional. And once I saw that as a trademark attorney, I said, this Kimra doesn't have her own apparel line. And who knows if I have an intent now to have an apparel line. So I went and I have a pending trademark for apparel. And I actually met the other Kimra. She's very nice, but this is business, right? So but I'm saying that I don't have a trademark for everything. So I have a trademark for legal services, just in case the other Kimra goes to law school, she can't have Kimra as a registered trademark. And then she has one for Kimra Luna, which is her name for her branding, marketing services. And then, but there's no one trademark for everything is my point. So a lot of times people think when they have a registered trademark, then they can just stop everybody. And so they think if they have a school, that they can tell somebody, no, you can't have the trademark for apparel because I have a school. Well, that's not true. You didn't pay for that to protect that class. So it's sold by classification. So you have an attorney's fee that you're going to pay. And if we're talking price, it's around $1,500 and starting at $1,500 and up usually. And then on top of that legal fee, then you're going to have a filing fee of $250 for every class. So that means if I have legal services, that's my legal fee plus $250 that goes to the trademark office. And then if I decide I'm also going to have an apparel line, or I'm going to start, a nail shop, that's a different class. So I have to pay a filing fee every time there's a different classification. So that's an explanation as to why you don't have a trademark that covers all the goods and services. These things are divided and you have to pay and pass the trademark office's standards to be able to have that protection in various classes.
It's a great point. And one other point to make, and why it's so important to have a lawyer, is that these fees are non-refundable. So, if you don't get your trademark application right the first time, if you don't get your copyright application right the first time, the Copyright Office and the Trademark Office, they do not refund these fees. So that's why it's really important to get it right the first time around. And even with those categories, those classes that Kimra just mentioned, that's really important too, because I run this out with my clients a lot too. They come to me and they say, oh, I have this brand. I wanted to protect, T-shirts, mugs, and,
right.
Cars and all these different things. And then that's going to be $10,000, so keep that in mind, that $250 fee per category. And a lot of clients always ask me, well, what happens if after I filed, I want to change that list of categories. Let's say when I initially filed the application, I just filed it for merchandise, but now I want to coffee mugs. And they always ask me, well, can I change it? Like after we submit? The answer to that is no. Once the application is submitted, it's submitted. We can't go back later and change it and add more categories. We would have to file a new application, for any additional categories that you would want your trademark to protect. I think another important thing to briefly talk about is how long, do trademarks last? How long do copyrights last? different types of intellectual property last for different amounts of time. So Kimra, if you want to go first and talk about, once I get the trademark, how long can I trademark? How long does it
Forever
last?
if you maintain it. So this is how it works. Let's say I got a trademark right here in 2020. In 2025, let's say I get it today. Today is February the 20th. So February 20th of 2025, I have until the same day of 2026. There's a 1-year window where I'm responsible for reporting to the trademark office to let them know I'm still using this, because they don't want you, the cyber squatting is an example. They don't want you holding on to this trademark and you're not even using it. So you have to report back, pay a filing fee that's about $125 right now, and plus any legal service fee if you have an attorney helping you with that, to let them know that you're still using it. So you have to report, you have to check in between the 5th and the 6th year. You also have to do the same thing between the 9th and the 10th year. And then after you do it between the 9th and the 10th year, it's every 10 years. You do have to report back to the trademark office to let them know that you are still using this intellectual property. And as the holder of the intellectual property, you're responsible for enforcing your rights. So let's just say, and this happens too, people will help me, they will come to me and say, I'm opening an apparel store. And when they have the apparel in 2020, then in 2025, if I go to the store, it might say sold out. So you can't have an apparel store with no apparel and then expect to be able to hold on to the trademark office. So they've really cracked down on this, because there are a lot of things on the trademark office register, like junk. So they're trying to clean up their files right now. So they have really, really been cracking down on the proof. For example, there are people out there who have applied for apparel, let's say, just naming different things in the application. For example, belts, shoes, socks, lingerie, swimwear. They had like 15 different kinds of apparel listed in their actual registration. Well, now the trademark office is doing audits, and they are saying, show us proof that you have swimsuits, show us proof that you have socks, where before they used to just accept a t-shirt, as proof, your one article of clothing, but now they're going back just to clean up the trademark office's records. So you can have a trademark for as long as you maintain it. And for the copyright, this is a good one. A lot of times people go online and they think just because you don't see a circled C for copyright, or they don't see any kind of name attached to the image that they want to download, they think that it's in the public domain. The public domain means something is no longer protected by intellectual property laws, just so everybody's clear. But copyrights last. The owner of the copyright is able to protect that copyright for the lifespan of the author plus 70 years. So if you're looking at something that looks pretty modern, then chances are it's not in the public domain. You can go to the Copyright Office and do a search many times to figure out who the owner is. But the rule of thumb is, if you don't know who the owner is, don't use it. That would be like saying, hey, I saw this child just wandering down the street and, I didn't see any parents, so it must not have any parents. I mean, it's kind of like that. There's somebody created this art, and you have to approach it like that. Like, the parents are going to come and get me if I use this, right? Anyway, that's just something. Creative Commons is an example of things that have been put in the public domain with some restrictions, right? So those licenses on there say, hey, you can use this work of art as long as you credit the author, or you can use this as long as it's for this. You have to read the license attached to it, not only for everything, for your stock images, whether it's music, whether it's art. These things have limitations. Like, you might have a royalty-free piece of music that says you can only use this in the US. And then if you have something that is worldwide that you're trying to launch, that you can't use that music. And so you really do have to read these long drawn out licenses, unfortunately, or hire somebody to do it for you, just so you can know what the limitations are. So copyrights, the lifetime of the author plus 70 years is the span. Trademarks, for as long as you can maintain them. You have to check in with the trademark office. Patents, lasts for 20 years, but if it's a design patent, then it's less time. The other thing is 10 years. The other thing I want to say is that you can get state trademarks as well. So that's another layer of protection. I don't know of a state that doesn't have trademark law, but what would be the point? Some people think that's redundant, but it's not. If I have a federal trademark, then I can get a state trademark to be able to enforce my rights quicker. Everybody knows how slow the government is, right? And also you can go into state court and get remedies a lot quicker. So you can get the relief, you can get a restraining order, you know, an injunction to stop the infringing activity, do things a lot faster if you have both.
Great point. And I know you were mentioning the word public domain a lot. And so for anyone who has no idea what that is, I'm just going to take a quick second to describe what it means. Public domain means any type of work that does not have no longer has copyright protection. So that means anything in the public domain, it means that there's no copyright protection attached to it and you're free to use it. A lot of things that are in the public domain, the copyright registration has expired for that work. And that means that, you know, we, the public, can use it for having, you know, any ramifications, any issues. So if you do a search on Google, you know, if you're looking for some work, whether it's music, you know, or art that you want to try to use for free for your work, do a Google search on works in the public domain, and it'll pull up a list of all the works now that you can use for free. Domain. And that list is updated every single year as copyrights expire every single year. So I think we're running out of time. I know we started late because of tech issues, but I just got a note on the screen saying it's going to wrap up soon. So just in case it does while we're talking, Kimra, can you share the best way for people?
I'm typing it in the chat. It's majormorrislaw.com. On social media, it's at Kimra ESQ. So that's where I am on all the channels. If anybody here is into gaming, I do have ip4gamers.com. I don't have my glasses on. I hope that turned out right. ip4gamers.com. I just released an ebook, so the official launch has not happened. So right now, if you put in gamers, it's at the top of the screen I did a Facebook presentation the other day. So it's $2 off if you want the ebook. But I'm so happy to have joined you, Jaia, just to share. I hope people learn something. Links, emails. Somebody's asking for our links in our emails. My email is info@majormorrislaw.com. Jaia, do you want me to type yours in? Hang on just a second.
And my email is, sure. And I'll also say it. My email is Jaia. You can use Jaia at jayathomas.com. And I'm on social Jaia Thomas. And before the program shuts off, maybe we can just answer a few questions. But also, if you guys are looking for any other type of representation, I also want to do a plug. Obviously, Kimra is an amazing IP lawyer. If you are ever looking for any other type of representation, like an agent, like a manager, like I have a separate company called Diverse Representation, which is a company focused on Black agents, attorneys, managers, and publicists in the entertainment industry. So if you go to the website, diverserepresentation.com, we provide a comprehensive database of Black agents, attorneys, managers, and publicists in the entertainment industry. We also host different events, programs, and initiatives. So if you're looking for any other type of representation, make sure you check that website out as well. And before the program just like completely shuts down on us, we can try to take a few questions. In the chat box, we can briefly go through them before.
I see a question that says, is there a template one can access to build a portfolio of work we produce that we can populate before we seek your counsel? Oh, that's a great question. So I do something called an IP audit. So we talk about the things that you've already created, because a lot of times people are learning about this after they've already been creators for their entire lives. And so we sort of get a priority list together as to what things are the most pressing. And then we go back and organize things, because as Jaia said, when you're doing a copyright, you can a lot of times do things as a collection. So we just try to figure out the most economical way and the most strategic way depending on what projects you're launching in the near future. So another one says, oh, the birthday song is not in the public domain. So yeah. So I wanted to talk about, can trademark and copyright ownership be passed on to children? Yes, thank you for asking that question. So again, you don't know, you can't protect what you don't know you have. But once you protect it, then you do make a record of these assets, these registrations and licensees and all this stuff for your trusts, and for in your will and in your trust. And you can have a holding company, have all this stuff clear. It should be in your estate planning documents so that your children and your heirs can benefit from these, hopefully, licenses and recurring fees that you're generating, or the revenue that you're generating from your intellectual property. So that's a great question. Thank you for asking that, because that's what it's all about. You're building this company, and then you want to be able to pass it on, and especially because we talked about the maintenance, right? So you have to maintain those trademarks to keep from losing them if you haven't left any instructions, and that can't happen. Okay.
Definitely. All right. Well, I think
I don't. So no, this is great.
See any other questions?
I'm glad.
Do you see any other ones?
It was really nice seeing you and joining you for this, and thank you to the conference. This is a fancy platform, right, Jaia? The Q&A has questions. Oh my goodness, the Q&A has questions.
Too fancy for me.
Hold on a second. So somebody, there are questions in the Q&A. Thanks for pointing that out, Sean. I didn't know to click there. So let me see. I'll start at the top. What kind of protection do creatives automatically have for their work? So that's copyright. We covered that. But you need a registration to be able to enforce your rights to sue people. And what protection do creatives need to seek? So yes, you need to seek out copyright protection. Go to copyright.gov, and I honestly don't think you need an attorney to do a copyright registration. Spend time learning that, look at the frequently asked questions, open a free account, protect your creative work. Can you talk about so-called orphan works? I did. Those are the ones that we should not be assumed to be in the public domain. Think about the child walking around scenario. These creative works have parents. How long do you have to use a brand or logo in the marketplace before it can be registered? You don't wait at all. You can actually reserve the name before you seek the registration. Let's see, what are the limits or guidelines for parody? It actually has to be funny that's a weird thing, but parody is a funny thing. You could say, hey, I copied this whole work and I made a joke about it. But if it's not funny, then you're going to have to pay some damages. Can trademark and copyright ownership? Go ahead.
And the other thing about parody we didn't really have time to delve into is that parody usually falls under fair use. And this is with regards to copyrights. And fair use is a defense for using somebody else's copyright without their permission. And so that would be an instance of a parody where we're using someone else's work and recreating it in a way without their permission. So oftentimes parodies do fall under fair use, where it gives the content creator the right to use the work for free, essentially. But fair use is on a case-by-case basis. And there are different factors that courts look at when determining a parody, determining whether or not something actually falls under fair use. It's very case-by-case, but it's something a lot of you should know about fair use. So, I would definitely recommend doing or just trying to read up on fair use, because it is a prevalent topic in the entertainment and with regards to content creators using other people's work to build off.
It is case by case, and for parody, it's a tricky thing because again, there are lots of cases where it was not funny, and you can't just copy paste. Educational commentary, those kinds of things. People think that it has to be for profit. And if it's not for profit, then it's fair use. That's wrong. You don't have to be making money to be sued for copyright infringement. So that's a really big misconception. So, yep, I think those are all the questions. So thank you again, Jaia and platform.
Thank you so much for doing this, Kimra. This is cool. You're the IP guru. And so thank you so much. Thank you to the conference organizers for feel free to reach out to either of us and enjoy the day and weekend. Thank you guys.